Hi, this is David Bliven, Bronx and Westchester divorce attorney with another episode of Lessons from the Divorce Wars. So this episode is kind of a buyer beware on attorney retainers. One really needs to read over carefully the proposed retainer of any divorce or family law attorney before they sign it. Most retainers right above the person's signature will say, I have read fully and completely understand this retainer. That means you should read it and carefully understand it. And if you have any questions, ask your attorney before you sign it. If your attorney is not going to answer those questions, go someplace else. But here's some highlights to be aware of. That are pretty standard in the divorce and family law field on retainer agreements. So the first thing to say is a lot of retainer agreements will have initial retainer amounts. These are not maximum fees. In almost all retainer agreements in my field, these are not flat fees. So they are partially refundable if the attorney doesn't earn the retainer based on their hourly rate, but they are not maximum fees. So fees can get to many tens of thousands or hundreds of thousands of dollars, so you really want to have that discussion with your potential attorney. The other thing to note is if, let's say, you're retaining your divorce attorney to do a divorce, and there's a family court case pending, you want to have a discussion with your attorney as to whether that retainer is going to cover both cases. Most of the time, they will not. In fact, my standard retainers will explicitly state it does not cover any pending family court cases. So if you want to join the two together, that's called a motion to consolidate, and you can join, generally speaking, you can join the family court case with a divorce case. But you definitely want to have that discussion because you don't want to launch into the case, you didn't read the retainer, and you're thinking in your head that now your attorney is representing you on all aspects of the case. Same thing with a family court case, by the way. So if you retain your attorney on a custody case and you have a child support case pending as well, most likely that retainer is just going to cover you for the custody case, not for the child support case. Why? Because it's a separate case held in front of a support magistrate, usually on a separate day from your custody case. So you want to go over that with your attorney and be clear as to what you're retaining the attorney on. Now, another thing to be aware of is it is standard in my field that the attorney will bill literally for everything they do. All their time is billable time. We actually have billing software, most attorneys in my field do, to capture all billable time and make sure that it gets onto the given invoice. So what does all time consist of? All time means, among other things, you're coming in, you're speaking with the attorney. That's billable time. I always give the analogy that, basically it's the equivalent of stepping in a cab. The minute you step in a cab, they put the meter down, this ticker starts, and you keep getting billed by that taxi until you step out of the cab. Same thing with an attorney. They're going to bill you for every second of the time. Some people, mistake and say, oh, well, the attorney only showed up to the courthouse, or I only saw the attorney at 9:06, and the attorney left court at 9:36, so I should only get billed a half hour, right? Maybe not. That's where you want to take a look at the retainer agreement. Does the retainer agreement also say the attorney gets to bill for their commute time? Something to go over, especially, like I'm a Westchester and Bronx divorce attorney, right? If you go to retain me on a Nassau case, I bill for my retainer, or my commute time rather. That's stated right in the retainer. I almost always say that to the person as well before they go to retain me. but it's stated explicitly in the retainer. So don't be surprised when, if you're retaining a Bronx attorney to do a Nassau case, that you just got billed 3 hours for a 1 hour appearance. It's also not, generally speaking, the case that you only get billed from the time that you visually see the attorney until your eyes leave the body of your attorney. That's not how it works. Again, even if they're a Westchester attorney and they walk right over to court, they bill from the moment they leave their office until the moment they get back to their office, generally speaking. So if your understanding is different, you want to ask that attorney going into retaining them, hey, how do you bill? If that's not otherwise made clear in their retainer agreement. Now, another thing that people get tripped up on all the time, because they don't read their retainers, no offense, you get billed separately, generally speaking, for every single text message and email. You can run into great difficulty if you don't have that understanding. And all of a sudden you start texting your attorney and send 10 texts in a day. Well, it's standard in my field that every single one of those is billed in a separate billing increment of 0.1. That's 6-minute increments. So that can add up really fast. That, if your attorney's billing $600 to $800 an hour and you send 10 texts a day, guess what? You just got billed for $600 to $800 for sending 10 text messages. So something to be aware of before you start texting your attorney. Another thing to be aware of, some attorneys charge surcharges if you call them on their personal cell phone. Why? Because, there's no offense, if you're going to call me at 2 o'clock in the morning, you're going to get billed extra. Sorry. The other thing to be aware of, emails. You get billed for every single email coming in, going out. Again, similar to text message, separate charges of at least 0.1 for every single email going in and coming out. So again, something to be aware of. If you're sending 2, 3, 4, 5 emails to your attorney every single day, you're going to get billed for every single email separately. Again, if you don't have that understanding going into the retainer signature, and that's not made clear one way or the other in the attorney retainer agreement, ask the attorney. Really, really key. So that you understand how that attorney bills. Other things to be aware of is some attorneys will bill trial retainers. So, in other words, you may pay one retainer to hire the attorney, and then the retainer agreement will say, hey, if a trial is scheduled in your case, you're going to owe an additional retainer of a certain amount. And a lot of times those paragraphs are somewhat buried in like page 10 of the retainer. So if you haven't read over the entire retainer, you're going to be really surprised when there are trial dates set in your case and all of a sudden you get an email from your attorney's office saying, oh, hey, pursuant to paragraph whatever of our retainer agreement, you now owe $10,000, $20,000, $30,000. Pretty pleased with a cherry on top, pay within 10 days. Well, if you don't have that kind of money burning a hole in your wallet, probably something to be aware of before you hire that attorney, and be crystal clear as to whether how often do they actually charge that? Is that just kind of fluff language, or do they pretty much always enforce it? What if they get, a client gets to that stage and their well is dry, they don't have any other money, how is it going to work? You want to have all those discussions with your attorney before you sign that retainer agreement. Other little nuggets to be aware of is some attorneys charge advance disbursement fees for things like, court fees, investigator fees, expert fees, reporter fees, deposition fees, subpoena fees, etc., process server fees. A lot of times the attorneys want those fees in advance. So it's not a matter of, oh, hey, well, I paid you $10,000, $20,000 to do my case. Shouldn't you just advance that out of the retainer? Sometimes yes, sometimes no. So you want to have that discussion with your attorney before you sign that retainer. Do they charge those things? Number one, the retainer agreement really should already say that and make that clear. But if you have any question or doubt about that, have that discussion with your attorney before you sign that retainer agreement. Be clear on it, because that's usually in bold or caps. That's what it says right above the signature on your retainer agreement where you sign that contract, and you have now just signed a binding legal contract to your attorney saying that you understand and agree to everything that they just put into their attorney retainer agreement. So be clear on stuff like that. Another thing that some people get tripped up on is they'll retain an attorney for a divorce case, and then there's particular motions or applications that they want the attorney to file, or that the attorney just, determines on their own, hey, this application should be filed, right? If the attorney goes ahead and files a motion, the client cannot usually go to the attorney and say, oh, hey, wait a second, I didn't authorize that motion to get filed. Almost all retainer agreements in my field will say, you're just retaining the attorney to represent you. Almost literally, period and end of sentence. In other words, the attorney has discretion, especially on procedural matters, to proceed in what they perceive to be the client's best interests. So you want to have that discussion with your attorney as to, where, that procedure stops and substantive applications start, so that you understand how that billing will work. Because you cannot usually get away with saying, oh, well, I didn't authorize that motion, so I'm not going to pay for it. Not the case, because your retainer agreement will generally say you're just paying for the attorney's time. You're not paying for any particular thing within the case that they do. You're just paying for their representation on your case overall. And if there is a dispute as to what they have done, and that dispute can't be rectified between the attorney and the client, that might be an impasse where you might have to decide, okay, I need another attorney. No offense to attorney number one. So there are probably many other things that I didn't even get to, but those are some of the most important things that you really want to make clear on in terms of signing an attorney retainer agreement in New York State on divorce or family law issues. So if there are similar questions that you have and want answers to, check out my blog. You'll find it at blivenlaw.net/blog. See you next time.